in enforcing these laws, the right that is available to the owner of the goods is lost forever. So therefore, there has to be expeditious disposal of these suits where rights are to be protected. So therefore, and there are a number of cases pending in the courts, as you all know. So what we are trying to do in the Delhi High Court as of present, and also in some other places, we are taking help of mediation. Now this is a new concept which has come in. We are trying to get some of these matters, particularly those matters where there are allegations of piracy, where are allegations of counterfeiting. They immediately, as soon as notice is received, they come forward. They say that we are ready for any solution. So we send them to mediation, get the matter settled within a period of 10 days or 15 days. Parties are satisfied, they get the protection, they could enforce their rights also, they get the damages paid, which is also in the nature of punitive damages. So we are, to some extent, wherever it is possible, we are bringing in the concept of mediation into these intellectual property right matters as well. Now, there are advantages so far mediation is concerned, because, you see, in these matters, there is always a trade secret involved. Now, this trade secret, when it goes to the court, it becomes public. But if it is settled through mediation, mediation is held only between the parties and the mediator. It can't go out of the room. It does not become public. So that trade secret is maintained. So that advantage is there so far intellectual property right matters are concerned, and I have seen multinational companies also coming in for mediation. You know about Levi denim jeans. Now there was a counterfeiting of that in India, Punjab. Matter was filed before the High Court. Notice was issued to that violator, the infringer. He came over. The quality of the goods was so good. The company, the owner, they immediately entered into a negotiation with them and accepted their goods and entered into a contract agreement with them that in future they will be their supplier. So this is the advantage. Win-win situation for both. They both gain thereby. So these are the advantages of mediation, and I believe if we accept this mediation, we will be able to get results, better results. We are also in the courts. We have a judicial training center. We are imparting training to the judicial officers so that they are alive to the situation, they are alive to the need. Special coaching is being held, special classes being held for imparting education on this side to the judicial officers so that they can dispose of the case well, because both the question of we are not only concerned with the disposal, we are concerned with the qualitative and quantitative disposal. Both quality is also required, and so therefore they are to be trained. Now the concept is, as you must have read in the newspapers, that Government of India is thinking of bringing in a commercial division. That was also discussed in a conference held here in the same venue about a month back. And London Additional Solicitor General is here, he will bear it out. It was done by his ministry. Now there, the minister has said that I am going to bring in a commercial division now, in addition to the civil division and the criminal division and the labor division. Now this commercial division now is thought of being started only at the level of the High Court, and that is also where the jurisdiction, pecuniary jurisdiction, is more than 2 crores of rupees. But according to me, this commercial division should be instituted at the lowest level. All these cases of IPR and arbitration and such other matters dealing with the trade and commerce should be dealt with by the commercial division right from the bottom, that is the subordinate courts. Also the High Court, there could be a separate division for dealing with, as in China, as also as in USA, commercial division will be a separate division right from the bottom right up to the top. That is also Supreme Court level. There should be a division as in China. China's Supreme Court has a special division, IP division. So we must also, I believe we must think in that line whether we can have a separate division so far commercial divisions are concerned. Because I believe that in order to deal with these matters, IPR, for example, one has to be trained. There has to be exclusive courts. It is the general court, a person who is not acquainted with IPR laws, its necessity, its requirement, it's difficult for him to pick up and then deal with the matter. By the time he learns, he is transferred to some other division. So that, I believe, could be avoided by having some exclusive courts, if not specialized courts, but exclusive courts for these, trying these cases. And I believe these are welcome changes that are coming in to our judiciary. And now I request to Mr. C. Donald Johnson to speak his views on the subject.
Thank you, Justice Sherman. I apologize for my voice. I lost my voice in the last couple of days, and it seems to be coming back a little bit. But the benefit to you is that I'm not going to talk very long. But I hope you can understand me as I talk. I happen to be more of a specialist in international trade than intellectual property, but I do know a little bit about intellectual property, and so I'll give you the benefit of a little bit that I do know, especially as it pertains to trade and as the issues that are arising in the United States. As you probably know, the Doha round has an intellectual property component on geographical indicators. And they want to extend the higher levels of GI protection that has been given to wines and spirits and other products, and then also to require that patent applications disclose genetic material and traditional knowledge used in the inventions. And it brings in the relationship between TRIPS, the trade-related trade aspects of international property. That agreement that was mentioned by Justice Sherman. They want to bring that agreement in with the UN Convention on Biological Diversity. Now, I just raised this issue. I don't want to talk about it very much because the Doha round, of course, as you know, has been a life support, and we don't know whether it's going to come back and whether they will continue these discussions. But that's the primary focus of multilateral issues on intellectual property. And the second thing I wanted to mention was the anti-counterfeiting trade agreement that is being negotiated amongst a number of countries. It would be a plurilateral agreement. That is, it would not be a WTO full, all the WTO members. It's whoever wants to join in can join in. And right now, the countries that are involved in this is Canada, the European Commission, Japan, Switzerland, the United States, the European Union, or I said that, Mexico, Morocco, New Zealand, and Republic of Korea, as well as in Singapore. So these are some of the countries that are involved in these discussions. And they've had 5 negotiating sessions. The primary function is to try to coordinate the effort and create some international standards for enforcing IPR, increasing international cooperation, and strengthening the enforcement framework that's particularly focused on commercial activities, commercial interests. The idea, too, is to raise the level of IPR protection in the counterfeiting area to higher levels than TRIPS. So it should be sort of like TRIPS Plus. It's been included in a number of free trade agreements that I'll mention, bilateral free trade agreements. There is a bit of controversy, particularly with the internet providers, because they want to include electronic protection of electronic copyright, try to get the cooperation of the internet providers, and many of them don't like this approach because they don't have to be policing their internet for copyright violations and so forth. The other subject I wanted to talk about just briefly is the free trade agreements that the United States has been involved in recently. They have had an approach to try to increase protection within the bilateral discussions with the bilateral negotiations with the countries that they're engaged in free trade agreement negotiations. This has also been true, I think, in the case of the EU. They've also tried to go for a TRIPS plus approach, and that's one of the problems, I think, with the EU-India free trade agreement. It seems to be a recent impasse there on that subject. But in the agreements that the United States has had, the last 10 agreements, they have included a TRIPS plus approach. And but in May 10th of 2007, the year that the Democrats took over power in Washington, and I'll give a disclosure here, I used to be a Democratic congressman myself. I kind of favor what they do. But they put a stop to using this TRIPS plus in many categories, especially in the public health area. So they reached an agreement with President Bush at the time to include or to change, in fact, some of the agreements that had been reached. The one in Peru, for example. But as I say, this is an issue that has been important not only in the United States but also the EU and a number of countries that they're negotiating agreements with them. All right, my voice is about to give out. I'll mention one other thing, and that is the Special 301 report. This is a required report that the Office of the United States Trade Representative, where I used to work, has to report to Congress every year the relationships that they have with other countries and any countries that they consider to be in violation or potentially violating the TRIPS agreement. And I just thought I'd mention last year's report. But it kept India on the special watch, 301 priority watch list, along with about 10 other countries, mainly because of the enforcement issue. They treat India as a special country to watch for. But they commended India for passing the Drugs and Cosmetic Amendment Act of 2008, which increases penalties for spurious and adulterated pharmaceuticals. And they also commended India for an e-filing system for trademark and patent applications. Thank you. My voice is running out.
Thank you, Mr. Johnson. Now, you have rightly said that so far Doha round is concerned is very relevant because India has also not signed that as of now. There is some debate going on. But so far, counterfeiting product that what you have said, now we also suffer from the same difficulties, particularly as I pointed out in my initial speech, that counterfeiting and piracy are two fronts where we'll have to fight hard, not only in the legal front, but also outside it. Now, so far European Union is concerned, they are also, you see, they are affected by this piracy and counterfeiting products. They are also affected by infringement of various products, and they have been in India. They are organizing seminars. They are trying to bring in awareness so far these intellectual property rights are concerned. But one difficulty that we have to deal with them is that they are following the civil law system, whereas we are following the common law system. So that's the difference with them. They do not believe in the precedents.